Hello, and welcome back to another episode of Intellectual Property. In today's class, we're going to be discussing the concept of authorship in relation to copyright vesting and ownership. So, as we discussed in our previous classes on copyright, the subject matter of copyright is original works of authorship fixed in a tangible medium. And we'll focus on the concept of an original work of authorship for the purpose of today's discussion, because that's going to be really driving the nature of authorship and the distribution of authorship among potentially multiple authors of a work. And as you recall, copyright protects the original works of authorship, or maybe better understood as the original elements of a work of authorship. In other words, the subject matter of copyright is the elements of a work that aren't copied from some previously existing work and have whatever kind of special sauce, whatever kind of creativity that the courts ultimately deem necessary for copyright protection to attach. So we know that we're talking about the original works of authorship, or the original elements of a work of authorship. The question then is, who's the author of those original works or original elements of a work of authorship? And what does authorship mean for the purpose of copyright protection? Well, under the Copyright Act, ownership of copyright vests in the author the moment the work is created. Right? So we've already discussed the fact that copyright protection comes into existence as soon as an original work of authorship is fixed in a tangible medium. And in fact, even during the process of creating a work of authorship, all of the original elements that are generated in the course of the production of the work are also protected as original works of authorship the moment they're created. So in other words, for example, if you write in Google Drive, for example, or Google Docs, which saves the different iterations of what you're writing as you go along, well, every one of those iterations that you create is independently protected by copyright insofar as what you created constitutes an original element of a work of authorship, even if you delete it from the eventual work, because it's still preserved. It's still fixed in the tangible medium of electrons and out there on the cloud, presumably perpetually, or at least as long as Google is still around. So copyright attaches the moment that an original work of authorship is fixed in a tangible medium, and ownership of that copyright belongs to the author of the work in question, right? So if there's only one person creating the work, well, then that person is the sole copyright owner. However, a work can also have joint authors. So if multiple people participate in the creation of an original work of authorship, then at least potentially all of the people who contributed could be joint authors, right? Rather than there being a sole author. And to the extent that a work encompasses multiple original elements, right, those joint authors would be joint authors of the entire work based on their original contribution. Now, there's kind of two theories of joint authorship and when joint authorship exists. So a joint work is a work prepared by two or more authors with the intention that their contributions be merged into a single work. And that's as the concept of joint work is defined in the Copyright Act. The trouble is figuring out what that means in practice. And there are a bunch of different cases that address the question of joint authorship, typically with an eye to whether or not a particular party is actually to be deemed a joint author for the purpose of the Copyright Act. So kind of two core elements here. First, the majority rule when it comes to joint authorship is that in order for somebody to be a joint author of the work, they have to both contribute an individual original element. In other words, they themselves had to have added an element to the completed work of authorship that is sufficient to constitute an original element, right? In other words, they can't just contribute an idea. They can't copy something from somewhere else. They can't contribute facts to the work of authorship, because none of those would independently be an original element of the eventual work of authorship. They actually have to make a contribution, an identifiable contribution made by them that is itself original and copyrightable for the purpose of the Copyright Act. In addition, in order for parties to be joint authors, they have to mutually want to be joint authors. In other words, they have to have made the work with the intention on both of their parts to create a joint work. In other words, the fact that one person thinks that they're making a joint work and the other person doesn't, at least in some circumstances, can preclude the eventual work created from being a joint work, right? Because in that case, there wouldn't be mutual intent. Now, of course, in some cases, you could infer mutual intent. You might look to the nature of the relationship between the multiple contributors potentially claiming joint authorship. You might look to the conventions and norms of the field in which they're participating in relation to joint authorship. You might look to any agreements that they have about credit for the work in question. But typically these problems come up where one party makes contributions to a work primarily produced by someone else. And then the question becomes, what does that secondary contributor have to contribute in order to constitute a joint author of the work in question? Because in the absence of a additional agreement, the joint authors of a work are joint owners in the same way that joint owners of real estate or physical property would be joint owners, in other words, they both are owners jointly of the entire property in question, right? So that would be a pretty strange outcome, or potentially undesirable outcome, if a particular author only contributed a small amount, just enough to qualify for potential joint authorship, but nonetheless was deemed a joint author of the entire work in question. So a lot of the doctrine around joint authorship has really developed as a means of ensuring that authorship vests in a relatively small number of people, right? So limiting the number of joint authors, which is especially a problem in works that involve the contributions of a whole bunch of different people. And essentially, the idea is to ensure that there can be some predictability, as it were, about who the authors of the work are going to be, and to ensure that people who make contributions that would not be considered authorial by a particular community or in a particular context won't nonetheless be considered joint authors simply because they satisfy the statutory conditions of the Copyright Act. So a lot of flexibility here, and the casebook discusses a couple of different circumstances in which joint authorship was disputed, and typically it hinges on whether the contributions made by the putative joint author were sufficiently substantial, and also whether there was a meeting of the minds on the part of the multiple potential authors as to the nature of what their relationship was going to be. So you can see a majority test. Minority test proposed by Justice Posner focuses more on the intention and less on the contribution. After all, as Posner points out, there could be circumstances where one agreed upon joint author contributed meaningful elements to a work of authorship, but didn't contribute original elements to a work of authorship. So the example Posner gives is, say you have two scholars who agree to write an article together. One scholar contributes the concept or the idea for the article, and the other scholar actually ends up writing the article in conversation, perhaps, with the first. Well, arguably, the first scholar hasn't contributed an original element insofar as copyright protects particular expressions of an idea, not the idea itself. So merely contributing the idea wouldn't be necessarily an original element. And yet, if both scholars agree that the resulting paper is a jointly authored paper, or should be treated as a jointly authored paper, Posner suggested maybe we should kind of defer to their beliefs about joint authorship rather than excluding the one who was part of this meeting of the mind about the nature of the authorial relationship, but nonetheless didn't formally contribute an actual original element to the completed work of authorship. Okay, now there's a different kind of authorship, namely a work made for hire. So what happens in that circumstance? If a work is a work made for hire, then the author of the work, for the purpose of copyright protection, is deemed to be the employer. In other words, when a work of authorship is created in the context of an employer-employee relationship and the relevant criteria are satisfied, then the author of the work is actually the employer, often a business of one kind or another, like a business entity, like a corporation or LLC, and the copyright vests in the author, right? So if the business is the author or the employer is the author, then copyright initially vests in the employer or business rather than vesting in the actual person or persons who created the work of authorship in question. And that can have consequences for the purpose of copyright protection, especially in relation to renewal and reversion of copyright interests, what's called termination of transfer, which belongs to the author and would not belong to someone who was participating in the creation of a work made for hire. Okay, so in the case of a work made for hire, the author is the business, and so the business begins as the copyright owner. Of course, copyright is also transferable by the author slash owner, right? So even if a work is created for a business but doesn't actually become a work made for hire, the author could still transfer copyright ownership to the business. Like a business can buy the copyright or otherwise receive it, right? But the nature of ownership is different because it didn't vest in them as the author, it was transferred to them after the fact. Okay, so interesting Supreme Court case touching on the concept of a work made for hire and how to determine whether or not a work is a work made for hire. So what happens in this case? Community for Creative Nonviolence is a charitable organization based in Washington, D.C. They want to create a float for a Christmas pageant in Washington. And they come up with the cheery idea of a float consisting of a homeless couple set up to look like the Jesus, Mary, and Joseph in the manger with the phrase, "And still there is no room at the inn." And the organization goes and brainstorms about who to ask to do this for them, and they settle on a African American sculptor named Reed, who agrees to create the sculpture for them, uh, essentially without charge, right? He charged them for the materials and so on, but didn't charge for his own time. And so they came to him with this idea. He produced some sketches and mock-ups. They had a conversation back and forth between the two of them about what the ultimate sculpture would look like. The organization made some suggestions, some of which Reed adopted, others of which he modified. And ultimately, he produced a sculpture in a kind of temporary medium that's supposed to look like a bronze, but wasn't actually made out of metal. They display the sculpture, seems to be powerful and effective, and so the organization wants to send this sculpture out on a broader tour as a way of further publicizing their mission. And Reed objects. He says the material that this is made out of isn't sufficiently sturdy to stand up to a big long tour. You really need to cast this in bronze if you want to tour it around the way you're choosing to. And he essentially repossesses the statue. And then there is a dispute over copyright ownership, right? Both CCNV and Reed claim to be the authors and therefore copyright owners of the work. Reed says, "I created the sculpture. I own the copyright in the sculpture." Community for Creative Nonviolence says, "No, we hired you to create the sculpture, and therefore we as an organization are the employer who commissioned a work made for hire for him." It's a little mean-spirited, right, in the sense that he did it for free, but nonetheless, CCNV says, "No, copyright vests in us. We're the employer, therefore we're the copyright owner, not you, Mr. Reed." Right? Moreover, presumably they were kind of thinking along the lines of, well, it was our idea. We asked you to do it. You do what we asked you to do. Therefore, we should be the author and the copyright owner. You are executing, in a sense, this work on our behalf rather than creating the work yourself. Well, case gets litigated all the way up to the Supreme Court, and the Supreme Court is presented with the question of what the standard for determining whether a work is a work made for hire or not is. And considered four potential tests, right? The test sort of suggested by CCNV either looked to the right of the putative employer to control the execution of the work, or the actual exercise of authority to control the execution of the work. And presumably under terms, CCNV would have been deemed, or at least arguably would have been deemed, the author insofar as they possessed and exercised significant control over Reed's ultimate execution of the work in question. They kind of told him what they wanted in the first place, and then they made suggestions and requests over time that resulted in the ultimate work. But there are alternative tests, right? One alternative test says a work is a work made for hire if and only if there's a formal salaried employee-employer relationship, right? In other words, unless somebody's on the payroll, then it's not a work made for hire. Then they're an independent contractor. They're doing it on their own, and the work made for hire situation doesn't exist. And then the fourth model is essentially relies on federal agency law to say, look, you look at the nature of the relationship, you weigh a range of different factors, and then you consider those factors in determining whether or not an employer-employee relationship existed for the purpose of copyright ownership, for the purpose of the work made for hire doctrine. Well, the Supreme Court rejects out of hand the control tests proposed by CCNV, and it also rejects the formal salaried employee requirement, which presumably was advanced by Reed, right? And it says, no, we have to look to the statute itself. The statute says a work prepared by an employee within the scope of his or her employment. Well, what kind of body of law do we look to ask these questions? The court says we look to federal agency law. In other words, we look to the factors provided by federal agency law to determine whether or not a work is actually a work made for hire in any particular context. So it's a fact-specific question that depends on weighing all these different factors against each other and then making essentially a judgment call about the nature of the work in question. Now, as a practical matter, it does seem like the work made for hire test seems to collapse into the formal employee test, at least in many circumstances. But at least courts are encouraged to consider other factors in making that determination. So presumably, if somebody created a work for an employer in the context of their employment and they were a formal salaried employee, the work made for hire test would basically always be satisfied. In a sense, what the Supreme Court adoption of federal agency law test is doing is saying, well, it might be a little bit broader than that. Right? There might be circumstances where somebody isn't a formal salaried employee necessarily, but the nature of the relationship is sufficiently substantial and pervasive that based on our evaluation of these different factors, the work is nevertheless a work made for hire, despite the fact that a formal salaried relationship doesn't exist. Now, notably, Section 101 defines a work made for hire in two different ways. So we've been talking about the sort of general definition as a work prepared by an employee within the scope of his or her employment. But there's a second entire element to the statute that at least that defines a work made for hire much more broadly to apply in different contexts by agreement between the employer and employee, if there's essentially an agreement, if there's a contract, this is a signed contract stipulating that the work in question will be a work made for hire. And this was a highly negotiated part of the Copyright Act because many businesses wanted to be able to make a work made for hire, even if the person in question wasn't actually a formal salaried employee. So, I mean, ideally, from a business perspective, you would just be able to agree to it in an agreement, and simply by calling it a work made for hire, it would become one. But that's not how the Copyright Act works, right? You can do it in an agreement, but only if it falls into one of the specific enumerated categories, right? And here, the sculpture in question didn't fall into any of those categories. So even a written agreement between CCNV and Reed, had one existed, would not have made the work a work made for hire, right? Because it fell outside the scope of the definition in the statute. right? So under the circumstances, CCNV had to prove that Reed was an employee for the purpose of federal agency law, and ultimately the Supreme Court said, no, that wasn't proven under the circumstances. Therefore, the work is not a work made for hire. Therefore, CCNV is not the sole author of the work in question. One might still ask whether CCNV could be a joint author of the work in question based on their contribution of an original element and at least arguable manifestations of intent to create a joint work on the part of CCNV and Reed. So not litigated before the Supreme Court, but at least a potential outcome as well when it comes to copyright ownership. Now, of course, the primary dispute there was really over the physical object more than anything else, but ultimately was litigated in the form of copyright ownership rather than ownership of the physical object. Okay.